Hi, I'm criminal defense attorney Aaron J. Boria, and today I'm going to be talking to you about your Fifth Amendment Miranda rights. So what is Miranda? You've heard it in cop shows and CSI and all those kind of things. Cop makes a bust and all of a sudden he's reading these Miranda rights to the person that he's got in cuffs. The Miranda rights go something like, you've got the right to an attorney, you've got the right to remain silent, anything you say can and will be used against you in a court of law, or some variation of that. A lot of people think that if they aren't read their Miranda rights, then the police somehow violated the law. Not all the time. Sometimes, yes. In order to understand how Miranda works, you need to know a little bit about the rules of evidence and trials. Because Miranda is going to play in usually at a trial. Under the rules of evidence, something that you said is hearsay. And when something's hearsay, the judge doesn't allow that information to come in for the jury to hear. There's an exception, and that is a statement against interest. That is not hearsay, and that does come in. So for example, the way this works, the officer arrests you. He reads you your Miranda rights. You say, I was the person that stole the item. Well, what you said is a statement against interest. So that statement is not hearsay, and when the police officer takes the stand in front of a jury and the prosecutor asks the officer, did he say anything, your attorney cannot object and say that your statement is hearsay, because the judge will allow it in under the rule of evidence that it's a statement against interest. Now, the flip side of that coin is that, let's say the officer arrests you, and you say, after he reads you Miranda, for the examples, I didn't steal the item. Well, first off, the prosecutor is probably not going to ask the officer what you said, because the answer doesn't help them. And when your attorney goes and asks the officer, didn't my client say he didn't steal the item? The prosecutor will object that the question that you were asking solicits hearsay, and the judge will not allow that answer to come in. And this is one of the main reasons why you should never talk to the police, because it doesn't help you. The only information that comes in is the information that hurts you, and the information that could help you stays out. Let's talk about a Miranda violation. Let's say for those same scenarios, you are arrested and the officer, without reading you Miranda, asks you, did you steal the item? And you say, yes, I stole the item. When we go to trial, or hopefully before trial, a motion will be filed to strike that testimony. At that point, because the officer did not read you your Miranda rights, and you were under arrest, or you were in a police custodial situation, your admission to stealing the item cannot come in, because the officer did not read you Miranda. He violated your rights. Miranda says that police can't question you without first letting you know what your rights are. If police question you without letting you know what your rights are, and you are under arrest, they're interrogating you, then any information they get is not admissible. This can win cases, and it can also get outright dismissals without even going to trial. Now, there is one other situation we should talk about, and that is where an officer arrests you, but he doesn't interrogate you. You volunteer information. Whether you have been Mirandized or not, if you just start talking and making admissions without being questioned, those statements are going to come in because you're volunteering the information, you're not being interrogated. So you should be aware of that. The bottom line is, don't talk to the police. I'm criminal defense attorney Aaron J. Boria. I fight for people that have been accused of crimes by our government. Give me a call and I'll fight for you. 734-453-7806 or shoot me an email at borialaw@gmail.com.